Good afternoon, everyone. My name is Alice Choi. I'm the Symposium editor of the Berkeley Journal of Criminal Law, and I have the privilege of introducing this panel. So panel 3 is on discretion in immigration. This session will explore how prosecutors and judges can use discretion to improve outcomes for non-citizens. Panelists will discuss how decisions prosecutors and judges make can impact immigrant defendants and victims. The session will also explore forms of relief that may be available to remedy immigration consequences retroactively post-conviction. And panelists will identify what immigration considerations prosecutors and judges should take into account at each stage of the criminal process. To introduce our panelists, first we have Professor Lucas Gutentag. He is a professor at Stanford and Yale Law Schools and a leading expert on immigration law. He founded the ACLU's Immigrants' Rights Project and led it for 25 years. Professor Gutentag has argued landmark Supreme Court cases and served in senior policy roles in the Obama and Biden administrations. Jody Linker, my former boss for the summer, was appointed the federal public defender at the Northern District of California in 2022, following 15 years as an assistant federal public defender. Following her graduation from Stanford Law School, Ms. Linker served as a law clerk and an extern for federal judges and worked in private practice. David Satnarine is special counsel for Immigrant Affairs at the Brooklyn District Attorney's Office, managing non-citizen justice policy and advising on immigration issues. As a proud Guyanese immigrant, he led efforts to protect non-citizens, secured convictions for immigration fraud, and launched Project Safe Refuge. David previously worked as an asylum officer at DHS. Raha Georgiani is the founder and director of the Immigration Representation Unit at the Alameda County Public Defender's Office, California's first such unit. She has provided pro bono representation to hundreds of detained immigrants and received multiple awards for her contributions to immigrant justice and legal education. And moderating our panel today is Anita Gupta. She is the managing attorney at the President's Alliance on Higher Education and Immigration, leading initiatives to expand employment-based immigration pathways for students in temporary statuses. Previously, she led the deportation defense team at the Immigrant Legal Resource Center and is an adjunct professor at Villanova University's Immigration Studies program. Please welcome our panelists.
All right, thank you so much, Alice. Kim Fox is a hard act to follow. We have the post-lunch crowd, so we're going to do our best to keep things interesting, but I'm very excited to be moderating this panel with such knowledgeable panelists. So I'm going to start with the professor on our panel. Lucas, you've had many different roles in the immigration field, and of course are a professor now. Can you first help us understand how the criminal legal system affects non-citizens in particular?
Excuse me, thank you. And thank you very much for the opportunity to be here and to talk about this. And thank you to Chase and everyone who organized this. It's been a great conference. And I'm going to try to give you a little bit of basic background. And then you're going to hear from four other people who actually know a lot about this. So let me just start with, and I think jumping off from the panel we had right before lunch, where the question was about sentencing and discretion and so on. I think the two big takeaways in terms of the immigration, the relationship of immigration, the immigration consequences, the criminal consequence for immigration, are one is that the sentence that's imposed is for a non-citizen is the first step in what comes. And the real consequence are the immigration consequences. And the second point that's critical is because of that, the Supreme Court recognized and held in 2010 that criminal defense counsel have a constitutional duty to advise non-citizens of the immigration consequences of their guilty pleas or of their convictions. And a constitutional duty to do that advice and to provide that advice competently. And as you're going to hear, it's an incredibly difficult and complicated area, but savvy lawyers and informed immigration experts can make a real difference. So it's essential to both understand the consequences and to consult with experts who know how to analyze those consequences and who can address them and craft pleas that take them into account. So I want to say a couple of things about how complicated it is, but starting out by just recognizing again what the Supreme Court said is that for a non-citizen, preserving the right to remain in the United States, and I'm quoting, is more important than any criminal jail sentence. That's what matters when the defendant is a non-citizen. Not to diminish the consequences of the criminal legal system at all, and not to diminish the consequence of being sentenced, of course. But there's something that follows that in many cases is even more important. And that's because the consequences are so harsh and categorical. There's oftentimes no relief available at all based on whatever the plea is that the person or what the conviction is that the person may have entered. It can require deportation without any exception. It can strip a long-time legal permanent resident, a person with a green card, of any opportunity to remain in the United States. It can prohibit the spouse of a U.S. citizen from ever returning to the United States. It can treat a minor misdemeanor under state law as a so-called aggravated felony under the immigration laws. And even if the immediate consequence isn't deportation, a criminal conviction and a plea infects every corner of the immigration system. It can end eligibility for citizenship. It can terminate protection under programs like DACA. It can bar a person from being eligible for asylum and other protections. There's no part of the immigration system that doesn't take into account if a person has a criminal conviction. And these convictions, and what makes it especially complicated, the conviction can seem almost trivial by normal standards, including for a legal permanent resident, and including for legal permanent residents who've lived here for decades and have U.S. citizen children, spouses, and so on. And that's why it's so tricky and confusing and why it's so essential to consult with an expert. A conviction, and I was going to go through a few of these to give a little bit of a sense, if that's helpful, just some of the specifics. A conviction does not need to be a felony in order to have consequences. State misdemeanors can have just as consequential effect as a felony. And some misdemeanors under state law are treated as felonies for federal immigration purposes and for federal law. The state label does not matter in determining what the immigration consequence is for an individual. It depends on how the crime's defined, what the elements are, how the elements compare to the federal elements. The name doesn't matter. And so, for example, even a minor conviction for marijuana possession or shoplifting can have devastating immigration consequences. So say, for example, a non-citizen is convicted of having possession of more than 30 grams, 2 ounces, just a little more than an ounce, a couple of ounces of marijuana who's outside the country. That spouse of the U.S. citizen is never returning to the United States. Or shoplifting. And again, it depends on exactly how the state law is written. But shoplifting can be what's called a crime involving moral turpitude, and I think we're going to hear some more about that. If the sentence that could be imposed is more than a year, and if a sentence for that is actually imposed, a sentence of more than a year is actually imposed, then even if it's suspended, then that becomes a so-called aggravated felony. And an aggravated felony is the immigration equivalent of the death penalty. It means basically that for that non-citizen, there's virtually no escape from deportation under any circumstances. So, and the problem is that under the Immigration Act, there's so many different crimes, so many different categories, so many different nuances that, not the aggravated felony definition alone has dozens of subcategories defining what constitutes an aggravated felony. But other convictions that are not aggravated felonies can also have devastating consequences. Controlled substance offenses, domestic violence offenses, including stalking, firearms offenses. And that's only one of the many complications, because in looking at how to define whether a conviction does or doesn't have, or what kinds of immigration consequences it has, in some cases, it depends on the sentence that could be imposed. In some cases, it depends on the sentence that actually is imposed, and in some cases, the sentence doesn't matter at all. And a suspended sentence or probation counts just as much as an actual sentence. So how a plea is structured can make the difference between deportation or not. And so, say, for example, it matters where a person got sentenced to, where it matters a case where the sentence that's imposed actually makes the critical difference. Say for a burglary charge, where it's if a sentence is imposed for then a year or more, then that can have consequences. And so that happens to someone, and then they come to you for advice. And you realize, well, this person shouldn't have pled to a year, so let's get the sentence modified to 364 days. Well, a modification of a sentence to ameliorate the immigration purposes, that doesn't count for federal immigration purposes, doesn't make a difference. That modification is not considered valid. And if the entire sentence, if the entire conviction is vacated in order to avoid the immigration consequences, that doesn't matter. It still has consequences. And if the conviction is expunged, that doesn't matter for immigration purposes. So the issue has to be addressed at the front end. It can't be addressed at the back end. But sometimes how the plea is structured can make a big difference. I'll just give one example from a colleague of few years ago had a case in New York where a young kid, over 18 obviously, but a young kid was charged, got into a fight in Times Square and got charged with misdemeanor intentional assault with a maximum penalty of a year or more under New York law. The prosecutor offered probation, no jail time. Right? Sounds like a pretty good deal, but this lawyer consulted with an immigration expert, one of the people on our panel, not literally with one of them, but one of the people who specialize in this, and instead offered to plead the defendant to a misdemeanor assault, but spend 2 weekends at Rikers jail, Rikers Island, not a place you want to be. But for the defendant, it made all the difference in the world to plead to reckless, even if he ends up spending some weekends in jail, which is not deportable, rather than to intentional assault, which is, for the prosecutor, great. Now this kid's going to spend a couple of weekends in jail, so for the prosecutor it was satisfied, and for the defendant it made all the difference. And so and the last point I want to make is the Padilla case, which held that defense counsel have this constitutional obligation to take the immigration consequences into account and to advise their clients, it's not just for the defense counsel. And the Supreme Court recognized this as well, that both defense counsel and prosecutors have an interest in taking into account immigration consequences, because it gives the prosecutor a big bargaining chip, and it gives the prosecutor leverage in the plea negotiations. And I'll just read what the Supreme Court said when it talked about this obligation to take immigration consequences into account in the criminal legal system. But the court said is informed consideration of possible deportation can only benefit both the state and non-citizen defendants during the plea bargaining process. By bringing deportation consequences into the process, the defense and prosecution may well be able to reach agreements that better satisfy the interests of both parties. Counsel may be able to plea bargain creatively with the prosecutor in order to craft a conviction and sentence that reduce the likelihood of deportation. At the same time, the threat of deportation may provide the defendant with a powerful incentive to plead guilty to another offense. So this is a constitutional obligation that exists in the criminal legal system that's incredibly complicated. We're going to hear about that, and that takes into account and serves the interests of justice by recognizing that for non-citizens, the criminal penalty is the beginning and the deportation is the harsh second step.
So we know that, convictions for many different types of offenses, even minor ones, can have really devastating and permanent consequences for non-citizens. We're going to go through the range of ways that prosecutors can exercise discretion for non-citizens. But Raha, let me turn to you. As a public defender, how would you respond to people who say, well, you shouldn't have committed the crime if you want to stay here?
I've never heard that before. Crazy question. I have a lot to say about that question. And actually, I hope this answer helps, especially the law students here and watching, because I know that question can stump some of us. It's hard to think of all the ways to respond. But I can give you at least 3 ways that I would respond to that. First, I think it's really important for people to understand that very often people's actions are a result of the trauma and victimization that they've experienced. Everyone in this room obviously is very familiar with those concepts, and that includes trauma that people have experienced in other countries, right? This is a spectrum of trauma that people experience. And so, this idea that people come here, people do not come here to commit crimes. People leave really sometimes amazing situations. They leave strong family ties. They leave livelihoods. Sometimes they're escaping from harm that is about to befall them or has befallen them. And so, crimes are a symptom of sort of deeper structural inequities that very often people don't have access to be able to change. So I think that question, one, should get turned on its head, right? Because people are not coming here to, in fact, to violate laws. They're coming here based on a set of circumstances. Secondly, and perhaps more importantly, I think that we need to be fair, and I'm going to go ahead and say educated and informed about where we start the story. And I'm a real fan of this, where do we start the story? I think very often the story is started when person X comes here to the United States without permission. Right? They come here without permission, and therein the story starts, and then 5 years later, they find themselves impacted in the criminal legal system or charged with some crime or convicted of some crime. But the part of the story that we almost always leave out is the part that happens before, and not just the part that happens before that we as a nation are not responsible for, but the part that happens before that we as a nation are responsible for. So if I went through my mind right now of the places that my clients are from, they're from Iraq, they're from Afghanistan, they're from Cambodia, they're from Vietnam. They are from places where this country has had a lot of very violent, very dangerous, very illegal interventions and interferences. That's where the story actually starts. And so we have a hand in that, right? And that causes people to be in positions where they have to then leave those situations. And so it's actually a pretty simple concept. If I come to your house and break down its walls and break down its windows and take away the water and poison the heating system and the water system, you might want to come to my house. And at that point, what is fair, right? And how important is it that we started the story, including the part where I ruined your house, and then you wanted to come to my house, as opposed to just started the story where you just randomly just showed up on my doorstep for no reason and wanted to come in. And then finally, I think we have to challenge this narrative of deportation as an appropriate punishment. As someone who has witnessed what deportation has done to families for approximately 19, going on 20 years now, I truly am a firm believer that deportation is absolutely cannot be used as a punishment. I'm not going to sit, obviously families are torn apart. Obviously that livelihoods are turned on their heads. Obviously that people are deported despite the fact that they've lived here for 10, 20, 30, 40, 50 years. They've very often, my clients have been here longer than I have, and perhaps have more of a right to be here than I do, because they've been here since 3 months old, 4 months old, right? So there's all of those reasons. But then let's get even deeper into the reasons. When someone enters the deportation system, a lot of the basic procedural safeguards that I think we assume in this country, in this what we like to think of ourselves as this democracy, I think that people assume there are, Fifth Amendment protections and Eighth Amendment protections and Sixth Amendment protections, and it would surprise people to know that there is no right to, protections from self-incrimination. There is no right to counsel if you're poor and you can't afford appointed counsel. There is no protection, Eighth Amendment protection in immigration, because we've cleverly categorized immigration as civil and not criminal. And so, even though we're shackling you, putting your hands behind your back, strip searching you, bringing you into a detention center, sending you hundreds of miles away, keeping you in detention for 3, 4, 5 years, it's just civil. It's not, we're not actually punishing you. And because we're not technically legally punishing you, you don't get the protections of double jeopardy. This is not in fact, it feels like another punishment, but it's not in fact a punishment. So it's not punishment, and therefore it doesn't benefit from the protections against cruel and unusual punishment. And there are plenty of other examples I can give. There are really, effectively, there is no speedy trial. Effectively, there is no statute of limitations. I can commit an offense, a minor drug offense, as Lucas pointed out, when I'm 20 years old, and I can face deportation for it when I'm 60 years old. And if you think I'm making extreme examples, I'm only giving you examples based on people that I have represented and cases that I have personally litigated. So there's a lot to consider here, and I would challenge us all to really actually completely rethink this narrative that deportation can even be an appropriate punishment. If we're gonna call it civil, then we should actually treat it as civil, right? There's a lot more I can say about that.
So taking all that into account, disproportionate punishment, the lack of constitutional protections in the immigration system, the root drivers of crime, David, at the Brooklyn DA's office, your office has instituted a lot of great immigration-focused policies. Can you tell us why it's important that local prosecutors really take a hands-on approach to immigration considerations, regardless of whether you're in New York or in the middle of the U.S. or your office size even?
So thank you for the question, Anita. Thank you, Jody. Thank you for the question, Anita. And again, Rachel, thank you for bringing me out here to talk about this issue. Chesa, thank you for convening this space. I am very, very fortunate to be the implementer of one of the nation's first formal immigration policies in a prosecutor's office in the country. In 2017, at the height of the first iteration of the Trump Muslim ban, DA Eric Gonzalez, who was the first Latino district attorney in the state of New York, implemented a policy commanding prosecutors not to just consider immigration consequences, but it made it a default position in our office that low-level offenses, or we're going to find what we call safe harbor dispositions, or dispositions that don't lead to deportation or the ineligibility issues that Lucas talked about, or immigration consequences for low-level crimes. And that's just the low-level crimes part of the analysis. The rest of the office, there's a presumption that we're going to try to find, if public safety allows, a disposition in almost every case that has an immigration consequence, something that mitigates that consequence in a way that at least we use our discretion to what we think is fair. Now, why is that important? I mean, it's easy to say in New York City, and especially in a county of Brooklyn, somewhere between 30 to 40% of the population of almost 3 million people in Brooklyn are foreign-born. I like data, and I think a lot of the people here are data-driven folks. If you look at the numerous studies that have been done, non-citizens commit crimes that are far lower rate than citizens. So some portfolio of our office is going to have these consequences in it when you have a population that we do of non-citizens. And you're going to find that we're a border state. New York City, Lucas, you know about this border search authority. When you're the gateway to the United States, like New York City is, in a lot of ways, we are a border city. We have such a strong immigration population in New York City that, like, this is who we are. It's a part of our fabric. So we should be considering this. It's crazy that this policy is only a 2017 policy. It took us so long to get here. But that's an easy answer for Brooklyn. But let's say you're DeKalb County or you're another jurisdiction where the politics of this are much, much more difficult. It's about equity and fairness. And I made some notes and I wrote a lot of things, but, I'm just going to say it in cases. When we look at someone like a lawyer that represented, a certain presidential candidate that didn't want to surrender power to another president during the election, and she was able to negotiate her criminal sentence to avoid the tag of something called a crime involving moral turpitude, so she can keep her bar license. Why is someone who has not been here for 30 years not entitled to the same thing? What makes her better than that person? It's an equity issue. When we look at, this one I can say, when we look at a famous entertainer like Justin Timberlake is able to plead down his case so he can keep performing, because, what is going to happen when he pleads down his DUI case to something else? Why is he better than the non-citizen that has a family to feed? Like, this is just all about equity and what we're messaging and what prosecutors message to people about where you are in society and how we value you. So whether you're a non-citizen in Nebraska or a non-citizen in Brooklyn, you should be entitled to the same, plea bargaining power and, mitigation efforts that any high-powered person with unlimited access to funds or a super PAC behind them to fund their defense, you should have that ability to find those same mitigation efforts. And at least in our office, we think it's just equity that commands us to do this. I think prosecutors have a unique role in the criminal legal system. Our role looks beyond an individual case. Our ethical duties require us, and I always say this, we're not here to win, we're here to do justice. And that requires considering these things. It requires to look at a person as a whole. And I can go on and on about how the outcomes from these creative, but they're not even that creative, these pleas reduce recidivism, keep families together, keep people in a position to do better than the moment that we encountered them. And that's not something that we find a lot in the criminal legal system. The recidivism rates are high when we reflexively just apply the system as we inherit it. And that can't be the way forward. So this policy does so well on so many levels. To me, it's just a no-brainer. Brooklyn, Nebraska, DeKalb, it works. It keeps us safe and it keeps families together, and it gives better results than the status quo that we've seen before.
So I also want to talk about the federal context. So Jody, in an earlier panel today, we heard briefly a comment about exercising discretion to not prosecute illegal reentry. What have you seen at the federal level in terms of non-citizen prosecutions, and how has that changed over the years?
I think if I weren't sitting here next to David and could feel that he was real, I would say he was a unicorn, because that is not what we see in the federal system at all. It's a very different conversation, and even with some of our most progressive administrations, we have still seen a huge amount of disparity of consequences, of penalties, particularly for non-citizens. And the dialogue and the social science and the data that supports this different approach that David's talking about often falls on deaf ears in the federal system. And I offered to pay for a trip for him to come out here and talk to our U.S. attorney out of my own pocket, because I think it's a really important conversation for prosecutors to talk to other prosecutors about, because it's not enough for just us as defense lawyers and just us as like-minded folks to talk about it. You sometimes need to hear it from somebody who's in the same seat that you're in, that has that discretion. Someone like Ms. Fox up there, and who was so amazing. But one of the things that I'll say is that I've been in the office for 17 years, in the federal defender's office for 17 years. And the spikes that we saw in illegal reentry prosecution, in immigration-only prosecutions, were not just based on party politics. Some of the highest rates of prosecutions that we saw for what are called 1326 illegal reentry offenses, which is being back in this country after you've previously been removed, were so high under the Obama administration. They really, really, really peaked under the Obama administration, and I saw that in my office. And when we would talk about these consequences and what would happen, the response was often, well, yes, that's why we're doing it. It wasn't that we're hiding from it, it's why it was being done. Interestingly, in our district recently, here in the Northern District of California, we've seen a low point of immigration-only offenses, so we're not getting the rate of illegal reentry cases charged right now. But that's not the only thing. It's not just the immigration offenses. What we are seeing are low-level drug cases being federalized to get folks deported. I mean, they're being brought to federal court so that people can be deported as a result. So talking about immigration consequences is, again, the response is yes, that is why we are doing it. That's what we want. And like Raha was talking about, a lot of the folks who are being brought in are coming from Central America, where we could spend a whole other many-day seminar on what our government did in Central America to cause the situation that exists now, for why folks need to come here in order to try and at least make ends meet and provide a little money to their family. So I think the conversation that's happening in the federal system is very different than the conversation that's happening in the states. But one takeaway that I think is important for everyone listening, and that all of us need to remember, when I went to law school and I knew I wanted to be a criminal defense lawyer, I didn't take immigration law. The idea, Padilla hadn't, I went to law school before Padilla was the law, and it was thought of as something totally different. And having folks like Raha in an office, having folks like David in an office, having people on both the prosecution and the defense side that actually understand immigration law so that they know what they're getting into, they know exactly what is happening as a result, is critical. So if you want to be a prosecutor, you want to be a defense lawyer, you want to do anything in the criminal justice field, I think it's critical that you take immigration law and that you be agile with it, that you are willing to play with it so that you can understand where it can bend, because that's where we can make the change happen, and that's where we can do some good work. I do just want to point out one statistic that I found out recently, which is that 76% of non-citizens sentenced for federal crimes between 2018 and 2023 were for immigration offenses alone. So that's a huge number. And at the border districts, where they're still charging a lot of these illegal reentry cases, it's happening in the federal system dramatically, even though it's dropping in our district.
So in the symposium, we've talked about exercising discretion at every stage of a case, charging, plea negotiations, sentencing, post-conviction relief as well. Raha, how do you and the defense attorneys that you advise actually ensure that immigration status is considered in plea negotiations, but also beyond plea negotiations?
Yeah, so I think we always start with getting the information that we need. So I think it's important for us to train the criminal defense lawyers that we work with to be able to basically be effective and accurate fact gatherers, because we can't give any of the advice unless we have all the facts. And then all the analysis that Lucas talked about really first starts with figuring out a person's immigration history, their immigration status, and their prior criminal history. So all of that is sort of this calculation that happens. I think the main strategy that we use, or what I guess Padilla attorneys who advise criminal defense counsel about immigration consequences of criminal convictions, now known as Padilla attorneys, I think the main strategy that we use is to be reasonable, right? So we want to understand, I want to understand as the immigration attorney in the office from the criminal defense attorney, what the district attorney's concerns are, right? How strong is the case? How weak is the case? Are there defenses? Are there not defenses? What are the hardest facts? What are the mitigating facts? And then what is the DA sort of interested in? Is it about felony versus misdemeanor? Is it I just need a felony? Is it I need this amount of time? It's really important for me that the person, do this type of time. Is it the nature of the offense? I don't care if it's a misdemeanor or felony. I don't care about time. I really, I want a priorable. I want some kind of domestic violence to be on this person's record. You would never say anything like that. But I'm just saying, hypothetically speaking. So I want to understand what the prosecution's goals and or concerns are so that I can tailor something, so that my response is not the person is facing murder charges. How about suggest a disorderly conduct and see how that goes, right? I want to be able to suggest something to the criminal defense attorney to take back that addresses some of the concerns while also addressing all of the things that we've talked about here, right? The non-citizens' concerns, the necessary mitigation, taking into consideration how long a person has lived here, taking into consideration that they're already going to be, punished under the criminal legal system before the immigration system takes them, right? So I just want to be really clear about that. When we're talking about immigration consequences, 9.9 times out of 10, we're talking about consequences that come after you have served your time, after you have complied with parole, after you have complied with probation, after you have taken the classes, after you have done the treatment, after you have signed up for everything you needed to do, after a certain period has passed, right? You have jumped through all the hoops and you are deemed to have served the sentence that, for better or for worse, whether we agree or not, society decided you needed to serve. You are on the other side of that. And then the immigration stuff happens to you. So just to kind of keep that in consideration.
And so, Jody, you mentioned all the challenges in federal courts. What does your approach look like in the federal context?
One of the places that I'll say where we as public defenders often are a step behind where already with non-citizen clients and all of our indigent clients, behind people who have retained counsel, is that when you have a retained counsel, you can usually go to the prosecutor before you've been charged. You get to go and negotiate things before. You get to make a pitch. You get to have a PowerPoint presented to the prosecutor of why you shouldn't be charged, or maybe you should get this charge instead, and why you're so sorry, and all the money you've paid back, or what's gone on. And that happens to people that have means. And one of the hard things as a public defender is you usually, well, for the most part, we don't get involved until someone's already been charged. They may be on a complaint, not an indictment, but they've been charged. And so the process has already started. And so that's an unfairness that already happens for all indigent defendants. And it's particularly prudent in this conversation when we're talking about should we treat non-citizens differently and how should we treat them differently? Again, like the example we talked about before, when you have a wealthy person that comes in and has a law degree and you don't want them to lose it, or a banking, they don't want to lose their Series 7 so that they can keep trading, and they're looking with the prosecutor to find some negotiated disposition that will keep their license, their real estate license, something like that. It's not unfair to do the same thing for a non-citizen. It is exactly part of the system. We are, especially in the federal system, a system of plea negotiations. 97% of federal cases result in a guilty plea. So few are going to trial. it is a system of plea negotiations, and we should allow non-citizens to negotiate in the same way that we allow others. And it's not a benefit that they're getting. They're getting to be treated the same as everybody else. So I think it's important to start there. I also think it's important, one of the critical points in a federal criminal case happens 3 days after we meet our clients, and that's the detention hearing. So in the federal system, most cases, they get brought in, and I'm not going to give a whole bail talk, but the way that the system works is that if you have a type of case that gives the prosecution a right to have a detention hearing, that hearing happens 3 days after you meet your client. And you have to get a lot of information. And like Raha's saying, like, you need to know your client, you need to know what's going on, you need to know their background, you need to know all of these things. But for our non-citizen clients, whether they stay in custody for the pendency of their case or get released, will have a dramatic effect on all of the immigration consequences, because we are federal, and so the federal prosecutors and ICE are in, it's now Homeland Security, but they are the same system, right? So there's no daylight between, like there may be in the counties, and there's a lot more coordination. Just getting your client out of custody 3 days after they are charged, if you can make that decision, will open up a whole world of what you can do to protect your client from getting removed from the country. And so that is a critical point in the proceedings, and one that often gets forgotten or ignored. And one of the great things is that as of 2015, if not earlier, but as of 2015, the Ninth Circuit said that whether an individual has an immigration detainer in place is not something that the judge can consider in whether they release or detain an individual. And so it used to be, when I started in the office in 2007, everyone used to just say, they have an immigration hold, they're staying in custody. We're not even gonna have the detention here. That has changed, and that has changed outcomes dramatically for our clients. So I don't wanna go through all of that. We'll talk more about the other pressure points, but I did want to highlight that one point that I think gets ignored, which is the bail determination. And Chase has done so much work in the state about bail. And in the federal system, we have a whole different, we don't have cash bail, which is great. We still have our other things that aren't great, but there are some things that are actually better in the federal system on bail, which is one of the bright spots that we have.
Anita, I wanted to, if it's okay, answer the second part of your question that I didn't answer, which is kind of going beyond just the traditional plea negotiations, right? So there's a lot that can be done in terms of negotiating with prosecutors so that they can wield their discretion in a way that both helps them reach, goals and address concerns they have, but then also mitigates certain immigration consequences. But we've found a lot of creative ways to go sort of outside the box of just, this plea and that plea. So one example I want to give you really highlights the fact that despite, contrary to a lot of people's beliefs that non-citizens are getting these amazing deals that other people necessarily wouldn't get, right? There's so much evidence contrary to that. One example is that non-citizens who have a defense can't always go to trial because the risk is too high. So whereas a citizen might decide, it's risky, I might go to jail for a year, but I'm going to take that risk because I think I have an innocence claim, and I'm going to take my chances with a year in jail, right? Taking your chance with your green card is a completely different thing. And so we regularly see non-citizens that if they had been citizens, we would say, you have an excellent case, let's go to trial, right? Let's exercise our constitutional right to trial, let's see what happens. And we're not able to do that. But one example of a situation we had where we were able to get a really great result working with a prosecutor's office is this. I had a client, I'd represented him 4 years in the public defender's office, finally gotten a green card, got him out of detention, stopped his deportation, got him a green card, and then he got arrested again. He had suffered from very severe mental health issues. It was a misdemeanor charge. It was a misdemeanor domestic violence charge, and he felt really strongly about going to trial, okay? The prosecution was offering, I'm going to throw out some numbers. It was a 273.5. The prosecution was offering a misdemeanor 243E1, which technically is immigration safe, or what we call immigration safe. That offer was already on the table. I couldn't convince my client to take the offer. My client wanted to go to trial. He felt strongly that this is his right and he wants to exercise his right. So I went to the prosecutor's office and I explained to them what was happening here, right? That there were mental health issues here and that no matter how I explained, but you're gonna lose your green card. If you go down on this other charge, you're gonna lose your green card, whereas if you take this offer, that's gonna be a safe thing for you. And so this whole thing that we have fought for years, right? You're gonna be right back where you started in ICE detention. I was not able to communicate that. That wasn't getting through. So my proposition proposal to the district attorney's office was, what if you drop the charge to what you're offering now? Right? You're already offering it. What if you just drop the charge to that so that if he decides to go to trial, the most he is risking is what you have already offered, right? So there are a lot of ways, right? People are different and they have different needs, and we need to meet people where they are and negotiate on their behalf based on where they are. Another example of something that we've been able to do is occasionally use detention time to negotiate with a district attorney's office over a sentence. So if I have a client that was arrested and then was whisked away immediately to immigration custody, did 2 years in immigration custody, and is now back in criminal custody facing those same charges, right? Because they ended up in immigration custody in the middle of all of that. If you have an immigration attorney embedded in a public defender's office, that's one of the things that you can do, is you can be informed and explain, right, to the district attorney's office that this person has already done maybe 2, 3, 4, 5 times the type of time that they would do on what you were looking for anyway, and to kind of use those, even though those systems are converging against a person, we can actually reshift those systems and try to get a result that is a just result.
And if I could just jump in really quick to build on that, because like one of the questions I get a lot from prosecutors and other prosecutors where I'm working with on these cases is, why are you giving this non-citizen a benefit that citizens don't get? And this, I think, Raha, your conversation highlights one of the things I say the most. These are not similarly situated people. That's a constitutional argument, but it's also a real and practical reality. A non-citizen is just not in the same position, facing the same charges on similar facts as a citizen is. And the realities are just so very different. And it's something I see all the time. And, as prosecutors, like Lucas, you gave an example, and I actually wrote it down because I was really disheartened to hear it, that the case where from the bar assault, or the assault in Times Square, where the non-citizen had to, there was a probation offer, but then in order to mitigate the immigration consequence, he had to spend weekends in jail. But to me, that seems overly punitive. If the case is worth probation and a misdemeanor, then we should find probation and a misdemeanor. Like, why are we extracting more just because they're a non-citizen? And that doesn't seem right. And these are the issues that we're perpetuating inequities. Not saying you, Lucas. But we see this even when we're trying to wield our discretion to help people. They're the biases that are built in. We're still going to have to take something from them just because they're a non-citizen. When in reality, us as prosecutors, we're not doing anything more. If a case is worth a misdemeanor and we want probation because we're looking for the hope of behavior modification through probation, we can have a long discussion of what that looks like and whether that's practical or effective. But to then make them spend time in Rikers, is that really furthering the goal that we had in the first place? And when we assess what is a case worth, that's where the conversation should be, and that's where I take the conversation with prosecutors all the time. What is the case worth? What is it actually worth? And if the case is not worth what we're charging, and if the case is not worth what we're trying to get just to get, then we shouldn't be offering that in the first place. Forget immigration. And that's where the conversations need to go. And it's great what you're doing, Raha, because you're taking those conversations in that direction with the prosecutor's office, because those are the things that work. Because in my experience, those are the things that work when I'm dealing with prosecutors. I'm a prosecutor myself. Those are persuasive things that we talk about of what is the goal? What does the finish line look like in a case? And prosecutors are not always good at that, and I'm going to be very honest. We're good at arguing about whether or not, something is a dangerous instrument and whether the law supports that argument. We're not good at finding community solutions to issues, and we can get better at that. And I'm hopeful, and I actually love my job because this is the one area of law where I think we lose some of the adversarialness and really get collaborative on finding good solutions going forward.
So when we talk about that collaborative approach where defenders and prosecutors can really work together to find a solution that mitigates negative immigration consequences, diversion often comes up. So Lucas, I think it's really important that for a diversion program to be properly structured so that it doesn't actually have negative immigration consequences. First, just help us understand, how does the definition of a conviction for state purposes differ from the definition of a conviction for immigration purposes?
Okay, let me try to do this, and then I invite as I said, our experts here to weigh in as well. But what's critical is that the immigration statute has a definition of conviction, and that's what governs. So again, it's what the federal law says, not how the state may view or treat a particular disposition. And what the federal law requires or provides is if there's a finding or admission of guilt plus punishment. And punishment does not need to be time in jail. It's any restraint on liberty constitutes a punishment for federal immigration purposes in defining what constitutes a conviction. So diversion or probation that might not qualify under state law can be or will be guilt plus punishment for federal law purposes. And some diversions that lead to dismissal for state law purposes will be convictions for immigration law purposes. Because an agreement that involves making a guilty plea, for example, that's later vacated, that vacator isn't effective for immigration purposes. And they need to be sure that there's no admission of guilt, which will be sufficient for the federal definition, even if it resolves the possible state grounds, and avoiding any stipulation on the record that constitutes an admission of guilt, even if it's not part of the formal guilty plea. And one of the things that's happening, and again, I think you all have more experience with this, but is that more and more diversion programs can be convictions for immigration purposes, again, because it's critical to avoid having any admission of guilt be part of what's in the diversion agreement. And I'll just reiterate what I said earlier, is that if a sentence is modified after the fact to avoid immigration consequences, that does not change the sentence for federal immigration purposes. This was a new interpretation of the law adopted during the Trump administration by Attorney General Barr, but that's the governing law now. If a conviction is vacated for immigration purposes, that does not qualify as a vacator for immigration purposes. It's still a conviction for immigration purposes, unless the vacator is for an actual procedural or substantive defect in the conviction. But if it's vacated for immigration purposes, that's not effective. If a conviction is expunged, that's not effective for immigration purposes. So in all those respects, resolutions that look like they're a good or positive disposition or avoids consequences under state law will not be effective under federal law.
So we're hearing a lot about what doesn't work, but maybe we can talk about what does work. So Jody, are there alternative programs or diversion programs or alternative sentencing options that you believe should be more widely utilized for non-citizen cases?
Yeah, and I think Raha talked about some of them, and Lucas as well, and David as well, of some of the ways that you can get around the immigration consequences if you have a prosecutor that's willing to play ball. Because it goes back to what we've been talking about throughout, obviously, the theme, which is the discretion, and there's so much built in. But if you you first, again, I'm going to repeat, have to know the immigration law. You have to either consult with someone that's an expert or know yourself. Does it matter if you get 364 days or is a year? That one day may make a big difference. So you need to know what you're pleading to and if it's immigration safe, and what you're admitting as well, because of what Lucas just talked about, that so much comes in that can be considered an admission. We have a bunch of alternative courts in our system in the Northern District of California. We are one of the more progressive federal districts that have, we have a convictions alternatives program. We have a young, they call it a youthful offender program, but it's for people 18 to 25. Now we just started a veterans court. We have all of these. They are not available to anyone that has an immigration detainer in place. And because we're federal, almost everyone that gets in our system, if they are subject to removal, will have an immigration detainer in place. So they are not eligible for our programs.
Jody, can you quickly tell us what is an immigration detainer?
Maybe Raha can tell us what an immigration detainer is. Basically a notice from the immigration agency saying, we're going to try and remove you. That's the easiest way to say it. We think that you are not eligible to stay in this country. We're going to put you in immigration proceedings, and you are likely to be subject to those proceedings. And then for most of our clients with federal convictions, will end up being removed. And oftentimes they have an immigration detainer in place because they already have been removed, or because they have what the immigration agents believe is an aggravated felony subjecting them to removal. So most of our clients have, if they are not citizens, even if they're green card holders, they may have an immigration detainer in place. Depending on what is going on with their status, where they are in their proceedings, they could have an immigration detainer in place. So a lot of our alternative courts is just another argument for why non-citizens are not getting a benefit. They're actually not getting the same benefits that everybody else is entitled to, and that's one example is our alternative courts. I would be remiss, I'm sorry that I was sort of smirking when David was talking. I just never hear a prosecutor talk like that. And he's not an AI bot. He is like here and saying these things. Most of you will not be dealing with prosecutors that talk like that. I'm sorry, you won't if you're a defense lawyer. It's not across the country. It's not as profound. And so I think it's important for us to also meet our prosecutors where they are and not just be on these principled arguments of we get in a policy debate of whether they should or shouldn't. I think the one thing that prosecutors across the board should be doing is an individualized assessment of the case. And that's one thing I hope we all can agree on. And where the debate sometimes comes up with prosecutors is, if I do it for this person, I'm going to have to do it for everybody, that slippery slope argument. And so where you have to meet your prosecutor, or if you're a prosecutor, where you might want to hear from the defense lawyer is why this individual is going to be different, what is going to change in their behavior. Because sometimes we have to talk the language about public safety. They want to hear, if I release this person, if I give them this break, if I do that, what is going to change in their life? And getting social services in place, getting drug treatment that is available to non-citizens, that's available to non-English speakers. One of the big things that we don't have a lot of in our district is drug treatment available to non-English speakers. That's ludicrous to me. If we want public safety, if we want people to stop using drugs, let's get drug treatment programs in place that are available to non-English speakers. So all of these things are to use the science, use the individualization to try and convince people that this client, this individual, this human should be given a different resolution.
Can I just build on that? And one thing, I don't know if I'm jumping the gun on PCR, but Lucas talked about the difficulty of the definition of conviction and vacators. And Chase actually reminded me of a case that somehow had the first connection to him that it didn't really register in my head until we started talking about it. I'm lucky enough to also, because I have this immigration nexus in the office, I do a lot of post-conviction work in our office. And it is a very difficult issue when you're dealing with immigration consequences and you're looking at inequities and you're looking to change the outcome of a conviction to make it what we call effective for immigration purposes. And a lot of that work allows me to actually look at the underlying older proceedings. And there was an individual case that Chesa actually knew a person who, from a very young age, got into a pretty bad situation. But because of that, I remember this case very well. I mean, he was Guyanese, I'm Guyanese. A lot of similar life stories growing up. I could have been him in many, many different ways. Had a bad instance, got into a lot of wrong place, wrong times, and then the system started compounding itself with its, sometimes I call it a horrible force, where, you get rolled into the immigration system, and then you get rolled by what I thought an immigration attorney that wasn't the best, that really didn't challenge a lot of the things that should have challenged, that led to a deportation order, it just created this horrible domino effect that it just infected his whole life. So lo and behold, he gets deported after his conviction, and I'm looking at this conviction from 1990 something, and I'm really digging in, trying to find, because I can't just say, Your Honor, this immigration result is really harsh. We really should just let him get a chance. Can't say that. That's not going to be effective. So I get to look at the old conviction, and I looked at the actual case. And there was an issue about who held a certain weapon, and the prosecutor in the case really had tunnel vision on this one young man. And I could not understand, as I'm reading the case files and reading the notes, why does the tunnel vision exist? Because the evidence wasn't there for the tunnel vision. So I was able to use that as a reason to vacate the conviction that's not related to immigration, that made it effective for immigration. And this person, if you look at his life today, is just an outstanding person. And I'm lucky to do that, and that feels rewarding. But he's so few of so many cases that we don't see. And how we exercise our discretion, even in post-conviction ways, of like not challenging this or challenging that. There's so many opportunities along the process in criminal prosecution, even on the PCR level, to not raise a legal challenge, to stand down, not to always stand up to fight. That would lead to effective results for people. That's all that I just wanted to talk about. There are ways, even on PCR, even with the difficult, definition of a conviction or the interpretation that A.G. Barr took in Matter of Thompson, the case that you're talking about.
Yeah, I think it's really helpful. It's not that under no circumstances can a vacated conviction not carry through. It depends on the reason for the vacator. And the irony, of course, is that like in the case you're talking about, the consequences are so much more severe for the person who's a non-citizen that is part of making the case for why a sentence ought to be modified or a conviction ought to be vacated. You might want to stress the immigration consequences even if the reason for the vacator is some actual procedural or substantive defect that would count. But then, from the immigration point of view, they're going to look at it and say, well, wait a minute, is this really for the procedural or substantive ground, or was it being done for some equitable reason that we, the federal immigration system, won't take into account? So it's great. I mean, that job, what you did is fabulous, and it's really important. And so it's not to discourage trying to get vacators or modifications, but the case then has to be put together in a way that will have the effect that we seek when it's presented for immigration purposes.
I want to piggyback really briefly on something that Jody said about how not everyone is going to sound like David, which then David went on to further prove that point. And that is that, right, so not everyone is going to sound like David, and we have to figure out how to effectively communicate with prosecutors. And I have found that one of the biggest misconceptions that prosecutors have is that something that happens in criminal court is going to bestow status on someone, right? This idea that if this conviction doesn't happen, or if I cut this person this break, and not even a break, if I negotiate around immigration consequences in a way that mitigates certain consequences, this person's going to become a green card holder. I'm basically handing them their citizenship right now, and that feels unfair to me, and so on and so forth. But that is absolutely not the case. Nothing that happens in criminal court can do that. I'll tell you what, it generally, 8 times out of 10, all that is doing is keeping a door open so that someone can plead their case. And that I hope that we all can agree on, right? I hope that everyone, regardless of whether you're on the prosecution or the defense, as a lawyer, as an officer of the court, I would like to think that we can all agree that people should be allowed to at least present their cases. And what we are doing when we mitigate immigration consequences 8 times out of 10 is we're literally keeping the door open so that some other person can decide whether or not this person gets to stay or go. And all of the arrests, all of the charges, all of the convictions, all of the allegations, all of the probation reports, et cetera, will be considered by that adjudicator in making that decision. So to the extent that it's helpful, I hope that all prosecutors, that we can help all prosecutors understand that this doesn't end there. So folks are still going to be effectively judged for whatever happened here. What you're doing is you are making sure that the door doesn't completely close, such as to make the difference between someone who gets up and is fully eligible for asylum, has a well-founded fear of future persecution by the government on the basis of one of 5 protected grounds, et cetera, but then can't say anything about it and has to just accept deport without ever even someone hearing whether or not they're really in danger.
So can I just say repeat something that Jody said? Is anybody who wants to go into the criminal legal system, whether as a prosecutor or defense lawyer, to pick up on what you just said, Roz, please take immigration law. Because if you take immigration law, you'll know that getting anything in the criminal justice system does not help you, right?
So I want to switch gears a little bit. So we've been talking about how complex immigration law is. But we also know that ICE heavily relies on the criminal legal system to arrest and deport people. We heard Jody talk earlier about immigration detainers and what that looks like in the federal context. At the local level, really, it's ICE saying, hold this person. When they are eligible for release from criminal custody, you must continue to hold them so that we can just come and pick them up and put them in deportation proceedings or deport them right away. So David, I want to return to you. What has your office's approach been to working with ICE? I know that your office actually sued ICE at one point, so tell us more about that.
So, I mean, at the Brooklyn DA's office, we take a position that we don't need to help ICE do their job. If they want to do their job, they have the full means to carry it out and do it themselves. And what that actually translates into is we are out of the business of civil immigration enforcement. And when we talk about studies, and I think Rachel Rollins, I remember when Rachel Rollins was in her confirmation hearings to become a U.S. attorney, she talked about this. As a person of color, and my mentor, District Attorney Eric Gonzalez, is a person of color. When people of color in law enforcement come with data-driven solutions and data-driven policies, they are always met with such disgust and disbelief. Study after study after study, going back to as early as 2009, the Office of Justice Policies within the Department of Justice have found that increased collaboration between local law enforcement and immigration agencies reduces crime reporting and increases crimes in certain immigrant communities. When you have that data that existed for so long, but yet we're still having this argument about whether or not it's a good idea for local prosecution to get involved in the business of immigration enforcement, the data doesn't support that. So in 2017, when DA Gonzalez became District Attorney Gonzalez, we held a non-cooperation policy. And then we took that a step further in 2019 because then ICE, in their infinite wisdom, decided that they are going to arrest people in criminal courthouses throughout New York City. In Brooklyn in particular, we saw an over 100% increase in the amount of arrests in local courthouses. And we're talking not just of people charged with crimes, we're talking of witnesses in New York. There was a specialized human trafficking court for victims, and that a witness was arrested. I mean, I sat across from rape victims, and I was trying to talk to them about going to court to testify. And I remember this conversation so vividly, it stays with me. And this young woman wanted to testify, but then she found out about the courthouse arrest, and she said, "Can you protect me from ICE coming to court? Can you be there? Can you do anything to make sure that they are not there?" And I could not give her a guarantee. And in that case, that I felt we had a strong case, but we needed her testimony, we had to do something else. And I don't think that she got justice in that instance. And so because of instances like that, our office, along with the Attorney General's office in New York, was the first time a DA's office ever went to court and said, ICE, you cannot do this. We're going to get a federal court injunction in place. And we won. We got an injunction in place that said that ICE cannot arrest people going to or coming from court for criminal cases. It then led to actual legislation in New York that codified that protection. And that's kind of where the situation stands today. But that's the power of discretion. There are so many different ways the DAs can exercise this discretion. And I know that it may not be a great political move, but when I tell you that this furthered public safety and the community trusts us more so we can go to court with victim testimony, it really did. And I know that might be harsh to say, on a panel with defense attorneys, but to be able to get the trust of a victim to come to court to say that we got your back and we're going to fight for that. That trust building thing does so much to build public safety in a community. So that was our effort in the Brooklyn DA's office.
I wish we could all just interact with people like David all the time. So I want to definitely make sure we have time for questions. So if you want to start thinking about questions and lining up, we will take those in a minute or two. So we know that immigration is a politicized issue. We have an election coming up, in case you didn't know. Criminal justice reform, also a very political issue. So Lucas, you were previously at the Department of Justice. What opportunities or challenges do you think a new administration might bring in this context? Briefly, if you may.
Let me just, obviously it depends on the administration. I think we're entering a time where there's less, not more sympathy for addressing, issues of immigration reform and treating immigrants with fairness and justice. I think that, there's the ability to exercise discretion on an individualized level, whether it's regard to how many 1325 or 1326 prosecutions get brought, whether it's how DHS charges individual cases, how the Justice Department defends challenges to removal orders in the federal that are brought in federal court, when it agrees to remand the case, and so on. So there's lots of discretion in individual cases that can be exercised. I think the more powerful role that the Justice Department has is in decisions that the Attorney General can make with regard to interpretations of the immigration law, and they are empowered to adopt legal interpretations that govern the adjudication system, the Board of Immigration Appeals, that govern the interpretation of the laws by DHS. There's been some of that in this administration. There hasn't been the level that I was hoping for. We saw the Trump administration use that power very, very aggressively in terms of like the effective sentence modifications and in other areas as well. So I think the challenge really is to mobilize and organize to demonstrate why the immigration statutes should be interpreted more generously. The power exists, the authority exists, but it hasn't been exercised in the same way. And I think one of the elements that has not been successfully communicated is that the structural racism of the criminal legal system that applies with a vengeance in the immigration system when it gets transported over, that connection hasn't been made in a way that's motivated even a Justice Department that I think is more sympathetic on issues of racism in the criminal justice system to understand the importance of bringing that lens to reform to the immigration system.
Thank you for that, Lucas. Why don't we take questions now? Go ahead.
Hello. Hi. Thank you so much for an amazing panel. panel. You guys really spoke on some important stuff that I'm sure resonates with a lot of us. Specifically for me, I worked in immigration for nonprofits, working with people who are stuck in detention centers, and I'm from the borderlands in Arizona, so super cool. Thank you. I had some thoughts come up when you guys were talking about, several things. One of them, I think it might have been Raha, maybe it was someone else, but talking about the federal system, how there's, you meet with the client and then you have the detention hearing in 3 days after meeting with the client. Who was that? Okay, sorry. And something that came to my mind is there's a program by DOJ and DHS that is still popping off in Arizona quite frequently, specifically in Pima County and Tucson, called Operation Streamline. And Operation Streamline, I'm sure you guys know, but if y'all don't, it's insane. It's basically the most, due process doesn't exist there. There's one attorney for I don't know, it can be up to 80 people. There's shoddy interpretation services, 20 to 25 minutes each with the client, if that. And the clock starts running before even the interpretation services happen, and it's hard to find someone who does Mayan dialect at 11:32 in the morning on a Tuesday, So I was just wondering, I think what you guys were talking about, and I think the theme of the whole symposium has been, just prosecutor discretion, and so I just wanted to, and I know that can be a solution for stuff but I'm not sure if that is true for Operation Streamline. It just seems so in a corner and almost unreachable. And so I was just wondering what your guys' thoughts were on what can be done for practices like Operation Streamline that, just sort of sweep things under the rug and don't even give people the due process. The right to, a hearing is really, the interpretation even is wrong and isn't done well. So just wondering what your guys' thoughts were on that in realm of this conversation. Thank you.
In the local DA's office, all I can say to that is that DA Gonzalez is very big on us not being a factory, that the criminal legal system should not be a factory process, and what you're describing in Operation Streamline is the antithesis of that. That's the only, comment that I can give to that.
I can kind of add to that. So I'm in Texas, and some of you have maybe heard of Operation Lone Star. I'm going to try not to rant about it, but essentially Operation Lone Star is a state directive that the governor has sent DPS or State Patrol down to the border, and they arrest people for allegedly criminal trespass for being on private land at the border, and they put them immediately into the criminal legal system, prosecute them, transfer them to ICE through ICE holds, and then deport them. So it's essentially utilizing the criminal legal system to criminalize migrants and deport them right away. No constitutional protections or due process. And the state has given actually a lot of money to counties to prosecute these cases. So there's a lot of incentive for these counties to actually prosecute them. That being said, there have been counties that started doing this, and for example, Kinney County at the border said, actually, no, this is not a good use of our resources. We see what you're doing now, and we're going to pull out. And so that was this is not necessarily, a DA that's considered progressive, but this is a DA that said, actually, I see what's happening now. This is not a good use of our resources. And actually, the local landowners don't even want to see this either. So we're going to use our discretion to no longer participate in this program. Any other questions before we wrap up? Go ahead.
Hi, thank you for this. I will caveat that I'm not a legal student, law student, or a legal professional. I'm a PhD student in public health policy. And in this panel and the last panel, I really been observing this through line of the use of social science research and evidence in your practice, in your informed decisions, in what you're doing and how you're doing it, both in a way in being exposed to good social science research to inform your discretional abilities. But also, I think it's really fascinating that in a way, I see a lot of what you're doing as acting as researchers. By every single case you're working on is updating your prior information of how you see the system works. You're identifying patterns. You're using that to kind of understand these different systemic injustices that are impacting the clients that you're working with. And I'm just curious, how do you see the future of social science research operationalize into your legal profession, and where would you like to see it go to help better advance your work for justice?
I can jump in. Thank you for that question. I think it's such an insightful thing to say based on what we all know in the system and how we're using the system. And we need more research. We need more studies. We need more social science to support it, because we do collect a lot of data and we try and run it ourselves, but it's hard because we aren't PhDs, most of us. I am not. And we don't always have what we know to support. We don't have evidence to support what we know, having seen it. So what I've seen for 17 years. So it would be great, and I think there's more people getting degrees that are both PhDs or masters in something and getting a law degree. And we used to see it only with science degrees. There were a lot of people that did or MBAs. They get an MBA and they get a JD, or they get some science so they could do patent work, and also a JD so they could make a lot of money. But I think it's actually really important. And I was sitting here thinking, I should go back and get a master's degree. Before you asked your question, I was like, my dad was what age when he got his master's in public health at Berkeley? He already had his MD. He was 50. I think I can do it. And so you are motivating me, because I do think we are in a data-driven society. We really are. And what our judges want, what our prosecutors want, is they want something to support it other than a defense lawyer saying, I believe this about my client. They want evidence to show. And we have some of that, and we point to some of that, and we use it. And one of the things that David talked about that really hit me is that, and Raha talked about, sometimes people don't want to go to trial because the witnesses that are on their side are non-citizens who aren't going to walk into a federal courthouse. So they can't do that. And the public safety benefits of having a safe harbor in our courts to allow people to report crimes, domestic violence, and other things, we need the social science behind it. And I think that there is more being done in that field. We try and collect data and use the data that we have, but it's not perfect data. And folks like you hopefully will do it.
Yeah, and I can say in our office, we actually, we're starting to try to use data as much as possible in every way. And I think IIP, you guys, Rachel, you helped us convene a study on biases in our system and in our prosecution disposition rate, and look and use data in social sciences to look to see where are the biases and how we plea out cases, and where cases fall systematically, racially, geographically. So I think that type of information is only helpful, because I know that as prosecutors, I think, and I would hope that at the end of the day, regardless of where our differences are, where we are on political spectrums, we're all trying to do what we think is right. But what we think is right should be informed by good data, and there isn't a lot of data out there. And we're only now seeing that in the last 20 years, post-war on drugs, of what good data looks like. So, yeah, do more, please.
I loved your observation, especially since I've always considered the work that I do as really like public safety and public health work, because I do think public defenders make us safer and healthier. And immigration law is, unlike criminal, and in some ways, in a criminal case, right, generally, the focus is on something that happened on a particular day. Yes, sometimes it's multiple days, but generally it's this event that happened. And the litigation is around whether or not it happened, how it happened, who did it, who didn't do it, and so on and so forth. In immigration cases, a person's entire life is essentially and effectively on trial. So what happened when you're 6 matters, what happened when you're 20 matters, what happened when you're 30 matters, whether you paid child support in this state or not, can come up in an immigration trial, 25 years later. Like it's basically a person's entire life. So we regularly rely on social science research and science research. The one thing that's, I think, already been said. The one thing I wanted to add is just, it's kind of been this dream of mine that like our social scientists and our scientists start speaking up more about the health impacts of what we're seeing, because we need those voices. So not just the use of the science and then we apply it in our cases, but we need social science and science activists effectively, right? Like, why aren't we seeing headlines that are like, deportation bad for your heart, deportation bad for children, bad for your brain, bad for your, right? Like this, I mean, there are real impacts. There are medical impacts, there are scientific impacts, and it would be really great and kind of long overdue to be able to hear those voices get into this, to these battles with us.
We have a question.
Hi, everyone. Thanks so much for being here. I'm a 1L here at Berkeley, and it's great to hear you all speak. I have a very quick question for Raha, which is that I was on the edge of my seat for your story, and I'm just curious whether in that instance you were able to convince the prosecutor's office to change the charge for trial to the immigration safe one in case your client wanted to go to trial.
Yeah, actually, thanks for asking that. So throughout all of the mitigation and conversations and discussions and information sharing that happened, they actually ended up dismissing the charges altogether. So, yeah.
All right.
Yeah.
Do you
Yeah,
have a question?
we've got 3 minutes if you'll take a short question. I feel like I was wondering about sanctuary city policies, and like I know I worked in SF over the summer. SF is famously a sanctuary city where not just like officials from the city, but like resources are not allowed to go towards working with ICE. And so I'm kind of wondering about, and yet there's collaboration with ICE happening in San Francisco right now. So just wondering about your thoughts on that.
You want me to? Do you want to go? No. You talked about it for New York a little bit. We talked about whether we were going to talk about this. And it's a whole other multi-hour, multi-day discussion. So in our now 2 minutes, have I filled enough time stalling to make it 1 minute to talk about it? There's an interesting debate going on in San Francisco right now. We are a sanctuary city. What is happening is there are low-level drug cases being fed to the federal prosecutors so that they can go through the federal system. Some may say that that is being done entirely to get around the sanctuary city policy. Some may say, no, the feds have total jurisdiction to do this, and there is a drug problem in the city, and this is a necessary use of discretion by the federal prosecutors to bring these cases and give what I will admit is a reasonable resolution for most of the people that, many of the people that otherwise wouldn't be brought into the federal system, that when they're brought in, we can sometimes get time-served fast-track deals, but they are removed from the country. It is a big debate. It is not something that we have time to answer right now, and I don't blame you for asking the question. I think it's an interesting thing that maybe stay tuned next time on Crimmigration. We will talk about that.
Okay, great. Do we have time for quick takeaways? Do any of the speakers have anything you really want to emphasize before we wrap up?
I'll just say that, we're entering a very uncertain time. The circumstance, or the situation, even under the best of circumstances, is extremely challenging. I think what you've heard is that there's an incredible opportunity to provide effective representation to individual people who are facing the criminal legal system and who are facing the immigration system. And there are great resources and organizations and lawyers to provide support and mentoring. So for those of you who are interested, I really strongly encourage you to go into this field and to tap into the expertise and the wonderful people that work on it, including all the people who you've been hearing from today.
Great.
I could say one quick thing as a public defender. I think from the defense side, I always say just be relentless. Never give up. Like just keep digging for more information and pushing and pushing and pushing. And that information, the jewel that you're going to get that's going to change the case is usually going to come from your client, your client's family, your client's background. And so use that individualization, get to know your client, and really make their experience something that you can make compelling to someone else of why they should listen. Because that's what you're trying to do. You're trying to convince someone, whether it's a jury, a judge, a prosecutor, a probation officer, a pretrial officer, someone. You're trying to convince them to see things differently. And the best thing that you're going to have is knowing your client, getting to know their experience, and sharing that and making it a compelling reason. And sometimes you have to just be relentless and never give up and just going back again and again and again. And oftentimes, like Raha's story, I have stories like that where prosecutors said no, and I just said no back. And then we finally got to yes. So have that energy to do it. I always say that as a public defender, you have to be like the circus or at the carnival, the weighted bottom clown that gets punched down and has that weighted bottom. And what's in your weighted bottom, so you're always going to pop back up and just keep popping back up and doing more.
If I could say, very briefly, I talk this way because I'm happy to be authentic, but, prosecutors are not always going to be well received to the way I speak or the way a public defender speaks about, their client's rights within the system. And but I will say prosecutors, for some of them, for many of them across the country, going out, doing this work goes out on a limb for them politically. So help them get to their answer, talk their language, know your audience, talk finality, talk conviction integrity, talk about ways that you're going to make this case be the closed case today that you're not going to revisit 5 years from now on reopening it. There are many different ways to communicate with prosecutors. Don't look for just a one-size-fits-all approach and just keep in mind, prosecutors generally, hopefully, are all trying to do what they think is right, so help them get there.
My colleagues did the beautiful inspirational closing, so I'm going to do the call to action closing. For those of you in California, Prop 36 is a really dangerous proposition that unfortunately and so disappointingly is being fully supported by Walmart, Home Depot, and the California District Attorneys Association. And so a lot of the things that we talked about, the aggravated felonies, those are going to become increased for immigrants. So now a petty theft is going to be more likely to be an aggravated felony, which means it can take your green card away for life. Simple possession is going to become an aggravated felony, which means it can take your green card away for life. So that's another form of prosecutorial discretion that we talked about, or that we didn't talk about, that I think is really, really important. I think prosecutors can and should get involved in also not supporting dangerous legislation and or investing in positive legislation for our communities. So if you don't know about Prop 36, check it out and vote no.
Thanks for that, Raha.
Sorry.
All right, we've run out of time, but thank you so much to our esteemed panelists, to Berkeley Law.